Good evening to everyone in the room. I welcome you all to a national webinar on default bail, the rights of prisoners without trial, on behalf of the Journal for Law Students and Researchers and Being Logical. We are thrilled to have Advocate Varun Katiyar as our speaker. Varun Katiyar, a practicing counsel at the Supreme Court of India, is also the president of Association of Indian Students. He has completed his law degree from Lawley Law College. He has been advocating for the welfare of the student body and has been successful in many of his matters for the same. Now, without further ado, I would like to turn the session over to Sir. Sir, I hand it on to you.
Thank you so much, Rohini, for this wonderful introduction. Today I'll be covering the various topics with regard to default bail, which has been derived in various Supreme Court judgments and has been there for a very long period of time. But people are not much aware about this right of their right. So before we start, I'll just share the screen for this with a presentation. Let's start with this particular things. So first and the foremost thing that has been derived, or the principle of criminal justice, that says that every individual who is charged with a crime has a right to be presumed innocent until proven guilty. Right. So this principle of criminal justice has been completely ignored with regard to the trials and various other aspects. But this was introduced and has been a part of a very important rule that every person who is charged with an offense should be presumed to be innocent until he's proven to be guilty. And for that example, I will give you an example for this. Most of us or the citizens of this country call a person as rapist or as a murderer, or in various circumstances various other names have been given to people, but then they come out to be, then they are proven to be innocent. But those people have been given those taglines, which has not only hindered their name but their personal and professional life as well. So this principle, though not implemented at lot of places, should be followed by us being as people who have knowledge about law, and most of the people who are attending this webinar must be lawyers, law students, lawyers, or other professionals from this field, legal field only. So we at least should have this responsibility of not only correcting the people, but also giving this knowledge to them that a person should be considered as innocent until he's proven guilty by the honorable and he's convicted for an offense, right? So next thing that comes into your mind would be how and when a person can be arrested, right? So a person, what happens, I'll make this picture more clear, how a person and when a person is arrested. The person is arrested, for example, a crime happens, and the crime is brought to the knowledge of the uh, preventive authorities, whom mainly police, or for special cases they are CBI and ED and various other departments, which are the preventive authorities who take into factor preventive or investigating agencies, right? So they used to misuse this law to of arresting people without following the due process. But Supreme Court, being a judicial organization and the most uh, apex court in this country, had decided to frame some guidelines with regard to how and when a person should be arrested. Right. So before moving on to that aspect of bail, we should know in which case and which guidelines were issued by the honorable court with regard to arrest. Because if a person is not arrested, how will you get a bail? And then specifically, if you talk about anticipatory, that is just one of the provisions of bail. So before going forward to bail, I would just take 2 minutes to point out an important judgment of Honorable Supreme Court with regard to guidelines for arrest. And these guidelines were laid down in Arnish Kumar versus State of Bihar, where Honorable Supreme Court has laid down various guidelines and principles with regard to how a person should be arrested and when can a person be arrested. Like if I read this, what Supreme Court said while delivering this judgment: arrest being humiliation, curtail freedoms, and cast scars forever. Lawmakers know it's also the police. There's a battle between the lawmakers and the police, and it seems that the police have not learned its lessons. The lessons implicit and embodied in the CRPC, right? This is what the observation of Supreme Court was when they laid down these guidelines with regard to arrest. And Supreme Court has also retaliated. There's this famous case of Muhammad Farooq, Farooqi, that comedian who was arrested, Manwar Farooqi, that comedian who was arrested by Madhya Pradesh police. He was granted bail by the Honorable Court on the ground that the principles laid down in Arnish Kumar versus State of Bihar were not followed by the police at the time of his arrest. So these principles have been made compulsorily to be followed at the time of arrest, and this process, if not followed, can become a ground for bail. This is the first thing, right? So then we come to what is the definition of bail, right? Because that is what will come into your mind. The very first thing that will come into your mind is what bail is. So bail can be considered as a conditional release of a person who is accused of an offense on presenting of some sureties. So now the technical points which come here is that it is a conditional release. Conditional release of the person based on the conditions which will be laid down in the order of the bail. For example, if I give you example, you guys might not be aware of cases which are not high profile. So I'll refer to cases which are high profile. So if we see the case of Aryan Khan was released only on the condition, on various conditions that were laid down, which were further struck down by Bombay High Court, and the order of was modified. But the conditions were that he'll submit his passport, he'll be going every Friday to the police station and sign over there. So there are few conditions which are laid down, and he'll take permission from the court before leaving the city or before leaving the country. He'll have to furnish. Or if we see with regard to Kartik Chidambaram, he has to approach Honorable Supreme Court every time before he has to leave the country. He has to take the permission from the court. Deposit. Recently, he had deposited 1 crore rupees as a surety amount before he left the country, right? So this is the very important aspect of bail, is that it is a conditional release. It's not that a person is set free in bail. It's just a conditional release of a person who is accused of an offense. So here, a person can be, see, if you come into this aspect of bail, then you'll have to understand the two concepts of offenses, the two nature of offenses. One is bailable offenses. Second is non-bailable offenses. One is bailable. Bailable means, in simple language or in simple terms, it is said the offense where the police has the authority or some administrative authority has the authority to grant you bail on furnishing of certain conditions. On furnishing certain conditions, you become eligible for bail in bailable offenses. But that doesn't mean that in non-bailable offenses you cannot get bail. There, the bail can be sought, and you have to present before the court with an application of bail. There are various types of bail which will come forward in the next, after this, will come forward. So the provisions with regard to bail are dealt in section 436 to 450 of CRPC, Code of Criminal Procedure, according to which the entire proceedings with regard to criminal acts or criminal trials is taken forward, right? So the next aspect is, see, when we come to this aspect of bail, there was an important observation of the Honorable Supreme Court in the state of Rajasthan versus Balchand case in 1978. And if I could recall this judgment was given by Honorable Justice Shai Krishna Iyer. if I'm not wrong, I might be wrong in this aspect, but he was the one who used to be very active in playing an important role in bringing changes in the judicial system, right, and the entire trials and everything. So Justice Krishna Iyer was, I believe this was his judgment. I'm exactly not able to recall. So what observation did Supreme Court gave in this particular case was that bail is a matter of right and jail is an exception. But what we have observed is, why I brought this judgment before you is because what we see as a trend is, at present, the more than 75% or 80% of the jails are flooded with under trial prisoners or prisoners without trial at all. That is also a matter which we'll cover in upcoming, like in the due course, right? So this observation, specifically this words of Supreme Court, where they say that bail is a matter of right and jail is an exception. This came forward since we had been granted various fundamental rights under Article 21. If we refer to the Constitution of India, on if we see that right to life and liberty was a fundamental right granted to us under Article 21, and then if we speak about the provisions of Article 22 of the Indian Constitution, where a person has the right to know and get represented by a where a person has a right to be represented by get a legal representation. He has to be presented before the honorable court within 24 hours of his arrest. No police can he has to be made aware about his legal rights that exist, right? So while delivering the judgment, Supreme Court also observed that it's not mandatory to keep a person behind bars just with the purpose. The reasons and arguments given by every public prosecutor when they argue the bail is that this person might flee away, that person might avoid that might create hindrances in the trial. So while delivering this judgment, Supreme Court said that it might not be necessary for a person to be kept in jail when that person can be available as and when required for the trial. That is very comfortable when this court said this particular aspect, that, for example, a person is arrested and he's ready and he's furnished, he's saying whenever he's ready to participate and move forward with the trial, then why should he be kept in jail just for the sake that he will flee away or he will not participate in the jail in the criminal trial? That is wrong. So this judgment of Supreme Court makes this bail as a right of the prisoners. So if we come to the records of NCRB, so these are the records of NCRB, which says the total number of people arrested, so and so, 48,57,230 people were arrested in special laws. Under IPC, 36,36,596 people were arrested. How many people were charge sheeted? 47,27,419. 32,99,161 under IPC. How many people are in custody without a charge sheet? 74,139. In under IPC, 2,94,857. How many people were granted bail? So if we compare the ratio of people being granted bail with regard to people who have been arrested, it's so less that we can see that this practice of granting bail in India is not very prominent, right? So next, we move to types of bail. Types of bail, there are various types of bails that have been that are there in the Criminal Procedure Code. The first of them is anticipatory bail. So as you can see from the term, anticipatory means a bail which is applied for in an anticipation of arrest. When a person anticipates that he might be arrested, that person can apply for bail and satisfy the court that when he is arrested, he might be eligible to the bail, right? So I'll put forward this case where P. Chidambaram, you got the anticipatory bail for a period for 6 months, and then that was continued for a long period, and he was getting anticipatory bail again and again but then his anticipatory bail was rejected and he was arrested. So provisions with regard to anticipatory bails are inscribed in 438, right? 438 talks about provisions with regard to anticipatory bail. Then we come to regular bail. Regular bail is just a matter of, regular bail means a bail which is filed before the court, where we try to convince the court that we will not apprehend the court and we have been wrongly charged, or we can satisfy the court that in case of any in case of the criminal trial, we'll always be cooperating and will be present before this court for every sort of help and in the present trial. So regular bail is sought in that case, and if the judge, so these all bail is always considered on the basis is always considered as a matter of right given to the judges, where they decide it on the basis of their judicial discretion whether they want to grant bail. If the judge is satisfied, they'll grant you bail. If that judge is not satisfied, he'll keep you in jail, right? Then there comes a transit bail. Transit bail is basically a bail which is granted for a short period of time for movement of a person from one particular jail to another. We see such type of bails being granted for a movement of a person or a prisoner from one particular jail to another jail. Specifically, like recent incident of this is like Mukhtar Ansari was moved from the jail from Punjab to Uttar Pradesh. So the police, Uttar Pradesh police sought for transit bail over there and in Punjab, and they took the transit bail and got that person to Uttar Pradesh, right? There, where this dispute even went to Supreme Court with regard to the movement of that person from that particular jail to this jail, where Supreme Court allowed the Uttar Pradesh police to bring that person to UP for interrogation and various other things, right? Now, when we come to interim bail is a short period of bail which is given for specific, very short period of time, which has not much relevance in law in this particular time. For example, a person is given bail just to attend his there are various functions. For example, somebody in his family has passed away and he has to go and do funeral. For example, his son has to do funeral of his father or some of his mother or some other person in the family. His presence is required. He might apply for an interim bail for a very short period of time. He can get bail from there. Then we come to the most important thing, that is today's topic, that is default. So I have created a background of what the entire bail is and why bail has been introduced and what is the scenario with regard to arrest and everything till now. Now I'll specifically focus on default bail. Default bail is a matter of right for the people who are without trial, right? Without trial, or if we go forward and read the provisions of CRPC, under section 167 of CRPC, it says and prescribes a time limit to file a charge sheet. Charge sheet is a collection of documents where police submits a report before the judicial authority that this is the entire report of the case and these are the evidences, these are the statements of various people. Charge sheet is collection of all the such documents which are required during the trial. Charge sheet and final report are two different aspects. Sometimes charge sheet and final report are same. Final report means the report of the judicial authority, where report of the investigating authority who has submits that this is the final investigation. But sometimes when a new evidence has been derived, they might submit a supplementary charge sheet also in that cases. So the time limit has been prescribed under section 167 of CRPC, where if we see, if the bare reading of this act, if this provision, what does it say? The procedure when the investigation cannot be completed in 24 hours. Whenever a person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours fixed by section 57, there are grounds for believing that the accusation or information is well founded. The official in charge of the police officer station or the police officer making the investigation, if he is not below the rank of the sub inspector, shall forthwith transmit to the nearest judicial magistrate a copy of the entries of the diary hereinafter prescribed relating to the case, and shall at the same time forward the accused to such magistrate. The magistrate to whom an accused person is forwarded under this section may, whether he has or has not the jurisdiction to try this case, from time to time authorize the detention of the such accused in such custody as much as such magistrate thinks fit, or term for a term not exceeding 15 days in the whole. This tenure of 15 days is a very important tenure. Why do I say this? Is because that Supreme Court has also confirmed this, that this tenure, that a person should not be granted a judicial or police custody for more than 15 days. And Supreme Court in recent has retaliated to this, saying that it's not mandatory that a person once granted a judicial custody cannot be granted police custody. They can be. But then also the term says, the court says that the condition is that it should not exceed more than 15 days. At any point of time, the tenure of a person being in judicial custody cannot be more than 15 days. The court has to again grant the 15 days. But then if we read further, if he has no jurisdiction for the case or commit it for trial and consider further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction, provided that the magistrate may authorize the detention of the accused person other than in the custody of the police beyond the period of but no magistrate shall authorize the detention of the accused person in custody unless under this paragraph for a total period exceeding 90 days. 90 days, first provision, where the investigation relates to an offense punishable with death, imprisonment of life, or imprisonment short for a term not less than 10 years. So this period of 90 days, and then if we go to second point, that says 60 days where the investigation relates to any other offense, and on the expiry of the period of 90 days and 60 days, the case may be, the accused person shall be released on bail if he is prepared and does furnish bail, and every person released on bail under this subsection shall be deemed to be released under the bail provisions of chapter 33 for the provisions of that chapter. So if we come to 167(2), that talks about default bail. What is default bail? Default bail is a bail where an investigation has not been completed in 60 days or 90 days as prescribed, depending upon the nature of the offense, and the punishment prescribed. That person has to be released on bail, and that bail would be considered as same as laid down in the provisions of the bail chapter for bail, that is 33, right? So if we say that default bail being a matter of right that has accrued upon the prisoner, so why I chose to keep this topic as default bail, right of prisoners without trial. Why this topic was chosen was because default bail is the right given to people who have not been charge sheeted, or where they are made an accused of a particular crime and they have not been charge sheeted for the same till date, and they're kept in jail for a period more than 60 days and 90 days as prescribed by the court. And even in that period of time, the police has failed to complete their investigation and complete their investigation, submit a report to the judicial magistrate. So in those cases, a right accrues to the prisoner to file an application of bail. So now this has to be done. For example, if a person has a right to file default bail, he has to file the default bail within. So he can file the default bail. For example, the tenure is 60 days. He can file the default bail on 61 days. And now the judges don't have the discretion to disallow this bail. They'll have to allow this bail since there was a failure from the investigating authority to complete those process at a specific time period. Right? This here default bail becomes a right. But then secondly, there's a major argument which says that what will happen if the person is granted bail? For example, a person is granted bail today and police files a charge sheet tomorrow. Does his bail comes to an end with filing of charge sheet? No. This is what has been clarified by Supreme Court. Supreme Court says that a person who has been granted a default bail, this bail will be considered as similar in nature as the bail granted under Chapter 33 of CRPC, right? So now the public prosecutor has to file an application for cancellation of bail. The same process as followed in the process when the person is granted bail. So public prosecutor has to file an application for cancellation of bail and appeal against the order of default bail. And only that person can, that bail, default bail will only cancel after that application for cancellation of bail is allowed. So this can be said as compulsory bail, default bail, or statutory bail, whatever we call. But this right to furnish bail in case when the charge sheet has not been filed by police officials within a time period that has been granted to them under the provisions of a statute, that is CRPC, under section 167 2. So this right to get bail has been granted to these people under this provision of 167.2, right? So now, when the recent case, so while I was making this PPT, this incident of Anil Deshmukh did not happen. The recent case with regard to, the recent case that got this discussions with regard to default bail more active was when SUDHA Bharadwaj was released on default bail. SUDHA Bharadwaj is an activist who was arrested in one of the cases in Pune, and she was kept in jail for a period more than 90 days. Right. So now SUDHA Bharadwaj filed an application for bail, default bail, on the ground that the judge, session judge of Pune Court, who had passed the order for extension of time period for police to file charge sheet, from 90 days by 90 days, did not have the jurisdiction to hear the application. So this point that a court can grant an extension for filing charge sheet would be discussed in later stages. Like I'll discuss it in later stages. So in the case of SUDHA Bharadwaj, what happened? SUDHA Bharadwaj was arrested and was kept in jail. She was in jail for more than 90 days. And now she realized that since she filed an application before the court saying that the judge who had given extension to the police to file charge sheet beyond the period that is stipulated, and since she was made an accused under the provisions of Unlawful Prevention Activities Prevention Act, UAPA, which is a special law, the courts have the jurisdiction. And this is not what this is what the law also says, that the court have jurisdiction to grant extra time since the matters are of serious nature and serious offenses. The court can grant you time based on the court shall be satisfied that you require more time to complete investigation, right? So when SUDHA Bharadwaj filed a case, bail application before the court allowed the application, saying, yes, you are right. The session judge did not have the jurisdiction to allow the police, Pune police, to continue investigation and file charge sheet after a stipulated time period and gave extension to them. But when there was already existing court of NIA court, which was already in existence over there, then this matter should have been heard by NIA court and the extension should have been given by NIA court. Why did a court without having its jurisdiction allowed the extension of the period? So that allowing of that extension of period is considered to be an illegal and cannot be considered as a foolproof process followed, right? So now this application was allowed by Bombay High Court. Then the appeal went to Supreme Court. In fact, Supreme NIA made an appeal before the Chief Justice for early hearing, not before the Chief Justice, before Supreme Court, for early hearing of the application of bail, challenging the bail of Sudha Bharadwaj. But the Supreme Court said, Supreme Court observed in this particular case also that Sudha Bharadwaj, what arguments were made on behalf of Sudha Bharadwaj were correct. That since a court did not have jurisdiction, it's not her fault. It is the fault of the public prosecution. It is the fault of the prosecution who failed to decide the appropriate court and move in proper application. They could have got an extension, but since they moved in application, the matter was heard and the order was passed by a court which did not had jurisdiction with regard to so the same was allowed. And Honorable Supreme Court did allow this process, right? So the default bail was also upheld by the Supreme Court, held by the Supreme Court that the default bail that is granted is correct in nature, right? So Supreme Court has from time and again been commenting on the record with regard to default bail. So I'll just bring few judgments so that this concept of default bail is more clear to you. Then I'll also tell you about a few new amendments that were not new, but new amendments that were brought to criminal trial or this process, which has created which has talked about more about rights of the prisoners, right? So while dealing this case of Rakesh Kumar Paul versus State of Assam, the 3-judge bench of Supreme Court said, like this was a majority decision, since you see that the quorum is of 3 judges and then there was a decision by 2:1, that a period of applying that the period of 90 days for availing default bail shall not be applicable to offences where the minimum imprisonment is not 10 years or more. Thus, for offences where the minimum period of imprisonment is less than 10 years, the default bail application can be filed after the expiry of 60 days. That is what this provision is also saying. If we see 167(2)(a) subclause 2, which is 60 days, if you read this provision, that is also making it clear. But then the Supreme Court in this judgment of Rakesh Kumar Pal versus State of Assam has confirmed the same, that where the offences of nature and the punishment is less than 10 years, then the imprisonment or the default bail can be filed within 60 days, right? So the next important case is, so this case where M. Ravirandran versus Director of Revenue Intelligence, Supreme Court said that has observed that the limited notice issued to the public prosecutor while hearing the application for default bail shall not be misused by buying extra time and filling up lacunas in the investigation. So what was the practice of police officials or judicial like these public prosecutors? They used to fulfill what all gaps they had in the investigation and everything. Supreme Court also said that this notice is issued to you only for the purpose so that accused, a person who's made an accused, does not run away or who does not suppress material facts, and whether the charge sheet has been filed or not, and whether the period of 60 days has expired, 90 days has expired or not, whether any extension has been granted or not. So this is what was observed in this case, right? So next case law that is very important is that Ravi Prakash Singh versus State of Bihar. The Supreme Court held that the period of arrest of 60 days or 90 days shall be computed from the date of arrest, first remand after arrest, not on the date of arrest, and the date on which the charge sheet is filed shall also be included, right? So if we see this, case of Ravi Prakash versus State of Bihar, the Supreme Court, the court has also given an observation in Gautam Navlakha case where default bail was rejected because that person was in the custody but was in house arrest for a period of around 36 days, for a period of more than 30 days, 32 days, that Gautam Navlakha was in house arrest. The court made it clear that the house arrest period shall be excluded, since his first day shall be computed from the day he was granted remand to the judicial custody, right? So this judgment, Ravi Prakash Singh, was referred there, that you do not have this right of default bail since this judgment, this period of 60 days has still not ended, or the period of 90 days is still not ended, because you were in house arrest and you were not, that remand was not given to you, to the police or to the judicial authority at that point of time, right? Now, this is one of the important cases that is with regard to that what I said to you, that the bail, like there was an error by the Honorable Supreme Court in while they observation was given by them in Sadhvi Pragya Singh Thakur versus State of Maharashtra. It was it was an error by the Supreme Court that this was admitted further in one of the another case, that is Nirla Yadav, that Supreme Court had done made error while laying down the foundations, laying down a correct law, and which was in counter to the Uday Mohanlal Acharya judgment, right? So the Supreme Court held that the provisions laid down in M. Mavarandan are true, right? So since we have covered the provisions of with regard to default bail, I'll shortly revise this and then we'll move forward with the question and answer round, right? So very first thing that comes to your mind is that every individual is presumed to be innocent until he is proven guilty, right? Then how and when a person can be arrested, the police has to strictly follow the provisions laid down in Nish Kumar versus State of Bihar. Then there are 5 types of bails. First is anticipatory bail. Anticipatory bail is a bail which is sought in anticipation of the arrest of a person, right? Third, second is interim bail. Interim bail is granted for a very small period of time. Like third is regular bail. Regular bail is normal bail application, which is filed on the grounds of merit, saying that since we have this right to get bail, as laid down in one of the judgments of Supreme Court in State of Rajasthan versus Balajan. And then we have a transit bail, which is granted for a period of transit for a movement of one person accused from one particular jail to another jail or some other movement that has done. Then there is a default bail. Default bail is what we discussed in a larger scenario. Default bail is a matter of right of people who are kept behind jail for a longer period than they should be without even beginning of the trial. Right. So before concluding this, I'll shortly bring you notice to 436A of CRPC, which is an amendment that was included in 2005 and a major change in the criminal trial procedure. Right. People were kept in jail, or you might have heard that people are in jail for 30 years and the trial is still going on. This was a recommendation by Law Commission of India that the person who is in jail should not be kept in jail for a period more than the prescribed punishment for the offense. Right. So this was the time when 436A was introduced. So this provision says that the maximum period for which an under trial prisoners can be detained is not more than 1/2 like no, it's not more than one, it's not more than half of the imprisonment that he has to suffer. And a person has to be released on bail if that person is still in jail and he has already completed the entire maximum prison punishment he was supposed to suffer, and the trial is still on. So he will be released on bail, and that entire period of the would be counted in this particular thing. So this provision 436A was introduced as a reform in the Criminal Procedure Code, and I believe that is all from my end. Now the uh, moderators can take questions, and just give me 1 minute. Just be give me 1 minute. In the meanwhile, you guys can collect the questions. I'll just answer them.
Okay, so if any students have any questions, they can write down in the chat box.
Any questions? Let's
Yes,
start.
sir. Yes, sir. The first question is, what would you say in the case of Vikas Dubey of Kanpur, UP? He was denied a fair trial, which is the right of every accused of an offense.
Right. So, not naming specifically any person, or it's not only about Vikas Dubey or various other people. There has been there's a very important saying that which we have seen since a long period of time, right? That right to free, fair, and speedy trial is a matter of fundamental right that has been granted to every prisoner. But this practice of police with regard to encounters, or what we call as fake encounters, has been increased, which will not never be promoted, right? And why to talk about only Vikas Dubey incident or any other incident? We supported the encounter when there was a when the police had encountered in Telangana, if I am not wrong, the people who were made an accused in case of rape. I do not support such offenses, but I say that there should have been a proper trial with regard to the same, and if they were guilty, they would have been hanged. I And then this question might arise that people say that there is a delay in justice. The I'll quote one of the things that has been there in the judicial system of the country, that says that each and every person, since taking life of a person is a very big decision, then that person shall be granted each and every opportunity of being heard. And that is the reason why I say that before hanging people accused in Nirbhaya case, they were given so many opportunities to approach the court. They tried each and every tactic in the book to get released on bail. So why only talk about Vikas Dubey, who is not granted proper trial? It is with regard to each and every person who dies in jail without a proper trial, speedy and fast, and trial, or free and fair trial, or people who have been encountered. Because what police does is, see, as a lawyer, this incident shocked me when he was not even given a fair chance to represent himself. Because of this situation, what I can say, the police could never have proved him guilty of any other incident. And coming from the same area which I am of, like I'm from Kanpur, so I know this incident very closely. And not only Vikas Dubey, I can say this, that police has encountered more than 100 people in that particular incident who have not even got a chance to put those things. Vikas Dubey was a very highlighted name, and that is the reason we know about them. But police had killed, I'll just say this term, that they had killed more than 100 people, and thus that has never been brought to the not notice of any authority, right? And the manner in which the incident took place, a person who cannot merely walk runs away, sitting in between the highly trained police official, the special investigating or the special task force was the people who were bringing Vikas Dubey from MP to UP, during the transit. These people were equipped with high profile machine guns and best weapons they could have, and are full given best trainings. And if a person who's sitting in between comes out and moves out, and they're saying that there was an incident, I do not support. And the judicial inquiry that happened and that gave clean sheet was, I cannot say that the inquiry was conducted properly, because if we go by for the facts, that is completely wrong. We should never ever, as a citizen of this country, should promote these activities, because today it is him, tomorrow it can be you. See, I say this with regard to everyone. So we should not promote these activities of police, because police might do this with you also tomorrow. So let's not. Every person who's been made an accused in any case should be given a free and fair trial, and that is with regard to each and every one. Being it Vikas Dubey, being a person who is accused, made an accused in any other offense, every person should be given the right to free trial, free and fair trial. The next question.
Yes, sir. The next question is, if charge sheet was not submitted by the IO on time, should we have any right for bail?
Shashi, yeah. So the default bail is a matter of right. Right. The entire webinar was based on this particular aspect, right? So first thing, if a police official fails to submit charge sheet, if for that, read the provisions of 167(2) that says that if a person is been made accused in a particular case, and that case investigation cannot be completed within 24 hours, then there is a period of 60 days and 90 days. 60 days in the case where offense is less than 10 years, and 90 days in the case where the offense is more than 10 years, until and unless a special law or a special permission is given by the court, the person gets a default right to ask for bail, and that becomes the right of the prisoner to get bail, not based on the judicial discretion of the judge, because other bail applications are with regard to uh, the discretion of the judge. But in this case, you have the full prescribed right to get bail if the police has not completed or completed or filed charge sheet within a stipulated time period, and then no special grant by the competent court has been given to the police officials, right? So this is what is with this regard to this. Okay. Next.
Yes, sir. The next question is, any views regards with Sunanda Pushkar murder case?
Sunanda Pushkar murder case. See, that is some matter of I do not. I can say that. See, in this regard, the investigation might have been there, and the matter is still under trial. So I would not comment on what is going on over there, and that since it requires high professionals, high profile people, it's better not to comment on things which are under trial and no evidence has been anything which has not been brought in public. So I'll refrain from answering this question with regard to Sunanda Pushkar, and any murder or any trial with regard to such cases, being it high profile or any case, should be done in fair and free trial manner. That is what I'll say in this case.
Sir,
Next.
the next question is the right to seek the default bail is a fundamental right?
See, it's not a fundamental right. It's a statutory right given to you under the provisions of CRPC. And it has been held by the Supreme Court also in various judgments. See, there are two types of rights. One is the right given to you under Part 3 of the Constitution of India, and the second is the legal rights that have been given to you by the various statutes. So, default bail is a legal right that has been granted to you by the provision of 167(2) of the CRPC, right? So, you see, this is not default bail. I'll again and again say this, that default bail is not on the basis of the judicial discretion, but it is the mandate which the judge has to give bail because the time period has elapsed and there has been no proper investigation and the charge sheet has not been filed, right? So next, please.
Sir, there are no more questions.
Okay. Which I can see any they can just ask. CGI has just, yes, Ganesh Bhatt has commented this. There's one more question by Nagaranjan K. Can you just read it out for me?
Yes, sir. Why not give knowledge of such civic rules at least from junior college level?
Okay, so he's giving a suggestion. Okay, so see, this era of social media, or what we say is that various things have devolved, since it's just sharing information is just one click away. You can share information, and that is the reason why more and more people are aware of these rights. So this matter of default bail has came to highlight again and again, and this recent incident of Anil Deshmukh yesterday itself, if you might have read on Live Law, that he has filed an application to get a default bail since he's been in jail for a period, and now his order has been reserved, and that would be announced on 20th of this month, right? So it's very important, and NALSA itself, National Legal Aid Service Authority, should be working on this regard to help more and more people come out of the jail. And why I say this is because, see, the number of people in jail, maximum of them are under trials, maximum of them are people who are who do not have the proper finances to fight or contest their case. They're not literate, or they're semi-literate, not aware about their rights, right? And this process of default bail is not very prominent in India, but if we see this in regard to England or various other countries, they follow it very seriously, and they give more importance to things like a person should not be kept in jail. Whereas in India, what we say is, and what we found is, that if we go by the data of NCRB, by point, the capacity of the jail, for example, the capacity of the jail is 1 lakh. And I'll tell you how many prisoners are there in jail. 1,15,000. 115% of the capacity, right? Not 100%, but 115% of the capacity. So this process, where India follows various theories of prevention of crime, why not we should focus more and more on doing speedy trials and releasing people who have been discharged of offenses. But the practice of keeping more and more people in jail has been increased, which should be discouraged at every point of time, and there should be a proper representation given to the people. And in case these people are not aware, then the National Legal Aid Service Authority, which was established with the purpose of helping the people who are not having the proper legal aid, should be given legal aid, right? So these authorities should come forward and help in this regard. Any other question? Then we'll wind it up.
Yes, sir, there is one more question. How to focus starting in criminal lawyer?
Focus in criminal. How to start focus in criminal law as a lawyer? I said, this, see, that is something which is difficult. Criminal trial is something which will involve not only one person. So there is this one very funny saying or observation by a judge. I'll not name that person. That judge said that you see the parties know who is wrong and what are the exact facts. The person who's on trial is the judge, not the party. This is what is said. So you will have to understand the each and every essence of the criminal law is more about evidences. Go on with regard to evidences. Now the era has come when circumstantial evidences have also been started admitted. The court has started accepting the circumstantial evidences and started giving judgment on the basis of that also. But this is not the practice. This is not the practice which has been there, right? So you will have to. It's a criminal trial, and this is just a matter of you'll have to focus a lot of things to get well versed with this fact, right? So any other questions?
No, sir, we are done with the questions.
Okay, thank you so much.
Lastly, sir, I would like to thank you for your presence. It has been an honor to share the same screen with you, and all over it was an amazing session, sir. So thank you so very much.
Thank you so much for inviting me in this wonderful session. I always like to speak on such things with regard to rights of people, and I'll want more and more people to come forward and work on these aspect of not only the supreme, like CGI recently made a statement where he said that more people should come forward and work with regard to legal aid and help the people who are